Hi everyone, coming out of a AOS marriage-based interview for a lovely client who had filed the application once and unfortunately hired an attorney who wasn't able to do the job correctly, so it got denied here in San Diego office. And we're in LA, but we do go to San Diego and other cities, so we had to refile this application and basically correct what was the mistakes that were made. So, a lot of people think that they can go through these things by themselves, but it is important that, there is a lot of details, and if you don't get something correct, then you could be issued requests for evidence. And, after you get issued a request for evidence, if you don't respond correctly, you could get your application denied, and then you got to refile again, and you lose your filing fees, which now are about like $2,400 if you're not filing for the travel permit. So, this client's a younger client, like a lot of my clients, but they obviously were in a real marriage. The applicant was understandably very nervous, and he was, even though I prepared him and calmed him down, he was still really just nervous because he had already gone through it. He had gone through the right steps, taken the right steps, filed his first application before he fell out of status because he entered with a visitor visa, but then because the application had gotten denied, he had fallen out of status, or he had been basically overstayed. And so he was nervous about that. And with everything that's going on now, as we know, there's announcements about USCIS potentially issuing notices to appear to certain people if they've been out of status when they file their applications. I made a video about that earlier. You can check that out, a little bit more details. But basically, anybody who is out of status, so your period of authorized stay has expired and you're filing for adjustment of status, a 485, you could potentially be issued a notice to appear before you're scheduled for an interview. And then if you are, then you could be placed in removal proceedings, and you can file that application in court again before an immigration judge, but it basically becomes a lot more expensive legally, and you're gonna have to basically hire an attorney to help you to do that. You're going to have to spend probably several months, if not years sometimes, to get a final hearing and get a hearing before a judge for that application. And then it's just a lot more contentious when you're in immigration court before an ICE officer. Because they're trying to deport you when you get to that point. So happy for this client. They didn't separate them, but a couple other updates is that, most recently I had a couple interviews in San Bernardino, and they are doing Stokes interview where they're separating some clients and they'll ask a lot of questions. Be careful about that. Be careful about any bias or, officers being overly aggressive and not being reasonable. I recently had an officer that wasn't being reasonable, and it just seemed because I asked to speak to a supervisor on behalf of the clients, he got even more emotional, and when he came back to do the questioning, it seemed very personal. So fortunately was able to request from the supervisor to have another officer, and that was granted. But it's important that we advocate for our clients. If you sense that there's personal bias being against that client and they're just not being given a fair shot, then as attorneys we do have to request that. When we waited outside for 30 minutes because we had to change officers, and the other officer came, and he was nicer. He separated them again, and he went through a lot of questions with them, but they basically answered every single question identically. So a Stokes interview, again, guys, is when they separate you, and they'll ask all the questions from one spouse first, and then they will basically have the other spouse sit outside in the waiting room. Once that spouse has answered all the questions, then they will take the spouse that they first asked those questions outside in the waiting room. They'll bring the other one and they'll ask them the identical questions, and they basically want to see almost the same answers for the most part, to be convinced that, okay, this is a bona fide marriage and we're going to approve the I-130. Obviously, this is only for marriage-based I-130 petitions. But if you are in removal proceedings, obviously the chances of them doing this is even higher. And fortunately, it was approved that same day. which was great for these clients. So it went from what seemed to be not a very good, an officer who probably wanted to RFE them and got fixated on some documents that about whether because they had children outside of their marriage with other people. They wanted to know why one of the parents wasn't listed as the emergency contact on the school's records, and there's so many other documents, and we pointed that out to them. But yeah, so these are a few updates. Make sure I would say now it's more important than ever to have an attorney evaluate your case if you're trying to do an adjustment of status or trying to do any kind of application, because things are getting tougher, guys. So if you have any questions, reach out, rodarmandelaw.com. Take care and stay tuned for the next update.